Good evening. This is Greg Seal, acting as justice. This is the Judge Barefoot Sanders Petitioner 1 team with Brooke Sanchez and Samira Morgan. Ms. Sanchez, are you ready to proceed?
Yes, Your Honor.
Ms. Morgan,
Yes, Your Honor.
you may begin.
May it please the court. Good evening, Your Honor. My name is Brooke Sanchez, along with my co-counsel,
Am I Samira Morgan?
and we represent the petitioners. Now, in September 2014, Robert Nash and Brandon Coach both applied for a concealed carry license. The state found that they did not demonstrate special needs and thus lacked proper cause. Under New York law, an applicant must demonstrate a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. This means that most New Yorkers cannot self-defend themselves when in threat or in serious danger. Now, today, the question before the court is whether the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense. And the answer to that question, Your Honor, is no. And we will prove this using text, history, and precedent. We will first explain how the text of the Second Amendment secures the right of the people to keep and bear arms unrelated to a militia.
Second, history confirms that the Second Amendment upholds the people's pre-existing right to bear arms beyond the homes.
And third, placing a de facto prohibition on concealed carry only allows guns in the hands of criminals and out of the hands of law-abiding citizens who need it for self-defense.
And lastly, the right should be a privilege protected under the Privileges and Immunities Clause if it is not recognized as a right under due process.
Now, our first argument is that the text of the Second Amendment secures the right of the people to keep and bear arms untied to a militia, because Heller rules that the prefatory clause does not limit the operative clause. Now, the Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now,
What is a militia, and why did the framers refer to it in the Second Amendment?
Well, Your Honor, a militia is simply the military force of the nation, consisting of citizens called forth to execute laws of the Union. They suppress insurrection and repel invasion. And the reason the framers refer to it is because of the Declaration of Independence. It states, it is their right, it is their duty to throw off such government. This introduced the right of the people to form a militia for this purpose.
Now, the structure of the Second Amendment is divided into two parts, the prefatory clause and the operative clause. Now, Justice Scalia, in the majority opinion of District of Columbia v. Heller, gave no attention to the prefatory clause, holding that the amendment's prefatory clause announces a purpose, but does not limit or expand the scope of the second part, the operative clause. The operative clause text and history demonstrates that it connotes an individual right to keep and bear arms. The right of the people to keep and bear arms is an individual right unconnected with the service of a militia.
What does the Second Amendment protect?
Well, Your Honor, the Second Amendment protects in Heller that we have the right to form a militia and also an individual right to possess firearms unconnected with the service of militia and to use arms for traditionally lawful purposes such as self-defense. Now, the distinction between keeping and bearing arms makes clear that a law-abiding person reserves the right to keep a gun in their home and carry a gun elsewhere.
So what is the difference between keep and to bear arms?
Well, Your Honor, the difference is keep means to possess, and while bearing means to carry, to have it on you.
And what about the word arms? What weapons does the term arms include?
Well, Your Honor, in the case Satano, they defined arms as being in common use at the time. And with the understanding of the Constitution being flexible with changing times, weapons that are protected under arms will be what is still or what has become in common use today. For example, a cannon will not be considered an arm protected under the Second Amendment, because as times have changed, cannons are not what are in common use in today's society. Now, the framers didn't intend for you to be able to carry, to keep an arm within your home and to carry it from one room to another. And that's seen in Prudhoe v. California, where they say that a right to carry an arm from the bedroom to the kitchen was not an intention of the founding fathers. With the understanding of the text, law-abiding people do reserve a constitutional right to carry arms outside the bounds of the home.
Second, history confirms that the fundamental values of the Second Amendment are to uphold the people's pre-existing right to bear arms beyond the home. Even before this nation's founding people reserved the right to carry arms outside the home. The 1328 Statute of Northampton is widely understood as limited to the carrying of dangerous weapons and unusual weapons in such a manner as we will naturally cause a terror to the people. Northampton
Counsel,
implies
what should courts determine is a gun control regulation that's considered long-standing?
Well, Your Honor, a gun regulation is considered longstanding if it is continuously used while also not limiting anyone's Second Amendment right. Furthermore, going back to Northampton, it implies the right to keep and bear arms with moderate exceptions. In modern times, this is seen when states ban arms in sensitive places to prevent causing terror to the people, such as a school, or even some states banning of open carry. The English Bill of Rights codified our pre-existing right to carry arms. The subjects which are Protestants may have arms for their defense, suitable to their conditions and as allowed by law.
What are the limits to the Second Amendment?
Well, Your Honor, the exact scope of the Second Amendment has been subject to dispute for more than a decade, quoting Josh Blackman in Penn State Dickinson Federal Society chapter. But we can see in Heller that it recognizes some limits as in sensitive areas, such as government buildings and school. And the only time that the Second Amendment has been ruled since 2008 in Heller was in 2010 in McDonald. So the limits of the Second Amendment have not been addressed by the Supreme Court too often.
And to continue, Your Honor, the English Bill of Rights have codified our pre-existing right to carry arms. It has been long recognized by the predecessor to our Second Amendment right. It identifies the rights from the English right to our Second Amendment as a similar provision. The English right did not strictly restrain the right to have arms connected to a militia, nor did it prohibit carrying outside the home. Even Washington, Adams, Jefferson, and so forth all exercised this pre-existing right to carry arms well beyond the boundaries of home. The sole reason we are afforded our Bill of Rights was to come to a compromise with the Anti-Federalists. Anti-Federalists feared a large central government would be too powerful, stating that the Constitution did not single out their fundamental individual rights. Fundamental rights such as bearing arms for self-defense to law-abiding people. Third, this court's precedent establishes the Second Amendment extends beyond the home. Heller recognizes the state's right to forbid arms in sensitive places. Justice Scalia specifically notes, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms, such as schools and government buildings. With Heller's conclusion of the right to possess and carry weapons in the case of confrontation, it is only logical to say the court applies the right to carry arms outside the home to non-sensitive places. You are less likely to face confrontation in a school setting, which is a sensitive place, rather than walking the streets of Chicago.
Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Yes, Your Honor, there is a difference. Open carry allows you to strap a gun over your shoulder and it's visible to the public. But concealed carry must be properly put away on the body, bag, or etc. It simply must be hidden. However, states have made legal differences, such as in the state of New York, in which it bans open carry in every form. But a resident may apply to a licensing officer for a concealed carry license. We can even look further into the Northampton statute, which regulated guns that would terrorize the people. With this connection, New York concealed carry is permissible since it will not terrorize the public. But, Your Honor, they do need to allow more people their pre-existing right to do so by making the law less strict. In McDonald v. City of Chicago, written 2 years after Heller, it reaffirmed that individual self-defense is the central component of the Second Amendment right. Blackstone's commentaries were able to process our deeply rooted history and assert that the right to keep and bear arms was one of the fundamental rights of Englishmen. The right of the subject is that of having arms for their defense, suitable to their condition and degree, and such as in fact are allowed by law. The fundamental right to keep and bear arms for lawful purposes of self-defense is consistent with this analysis of Blackstone's work. In Catano v. Massachusetts, it strongly implies that the Supreme Court striking down a law that prohibited stun guns outside the home. Stun guns are protected in and both outside the home.
Now, prudential considerations suggest that placing a de facto prohibition on concealed carry only allows guns in the hands of criminals and out of the hands of law-abiding citizens. By placing a prohibition on concealed carry, it only prevents law-abiding citizens from obtaining guns. This leaves those citizens unprotected while criminals are able to get their hands on guns. Now, Bessario, in his book titled An Essay on Crimes and Punishments, states that, quote, laws that forbid the carrying of arms disarm only those who are neither inclined nor determined to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage that prevent homicide, for an unarmed man may be attacked with greater confidence than an armed one. Laws that prohibit the use of concealed carry will only dissuade those who obey the law, making it much easier for them to fall victim to crimes. The right to self-defense is a fundamental right to the nation's scheme of ordered liberty as in deeply rooted in our history. Now, by providing only a few people with the broad proper cause standard for obtaining a license, public safety outside the home is left defenseless. We can date all the way back to the American Revolution. Samuel Adams, a key and influential part of the Revolution and founding of America, believed in the rights of the colonists' duty of self-preservation. The idea of self-preservation and self-defense were essential in developing the Second Amendment. By allowing this prohibition, we are harming law-abiding citizens and infringing on their right to self-defense. We would instead be empowering criminals by giving them the advantage. Those who obey the law will not carry, leaving them defenses for crimes such as robbery.
And lastly, if this court does not wish to recognize the right to carry outside the home as a fundamental liberty under due process, it should.
Counsel, before you go to this last argument, let me ask you, what is strict scrutiny, intermediate scrutiny, and rational basis review?
Well, Your Honor, those are the three judicial review tests. And in order of complexity, rational basis review is generally used in cases where no fundamental rights are at issue. Now, to pass the rational basis test, the statute must have a legitimate state interest, and there must be a rational connection between the statute and the goals. Now, you can see that that is a very easy standard to pass. Now, the court has a next level of scrutiny, which is intermediate scrutiny, which is less rigorous than strict scrutiny. This test applies in equal protection cases as well as in some First Amendment cases. And in order to pass intermediate scrutiny, the challenge law must be furthered and an important governmental interest. And they must do so by means that are substantially related to that interest. Now, lastly, moving to strict scrutiny, which is the highest standard of review in the Supreme Court. And in order to pass this test, the challenge law must be a compelling governmental interest and must have narrowly tailored goals to achieve that interest.
You talked earlier about individual safety implications, but how should the court consider the public safety implications of licenses to carry firearms?
Well, Your Honor, public safety is in fact a governmental interest, but what the Supreme Court should be applying is strict scrutiny. And not only passing the first prong, they must also pass the second prong, which is it has to be narrowly tailored. And placing a de facto ban on licenses to carry does not pass the least restrictive means test under any circumstances. What New York has done is they've created a circle of people who are allowed to carry guns, and they've put everybody on the outside of the circle, only allowing a couple inside, which you're not supposed to do that when the right to keep and bear arms is a fundamental right. Everybody should be within the circle, and they should exclude the people who are not law-abiding people who don't reserve the right, such as felons. Felons cannot openly carry or conceal carry guns.
And lastly, Your Honor, if this court does not wish to recognize the right to carry outside the home as a fundamental liberty under due process, it should recognize the right as a privilege protected by the 14th Amendment under the Privileges and Immunities Clause. The Privilege and Immunities Clause states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. In McDonald v. Chicago, the court held that the Second Amendment right to keep and bear arms for self-defense in the homes applied to the states. The court applied this through the due process clause of the 14th Amendment. The court ruled that the right to keep a gun for self-defense in the home is a substantive right, but did not rule on whether carrying a gun outside the home is a fundamental liberty. If this court were to decide that it is not a fundamental liberty under the due process clause, it is still a right that has been preserved for citizens. The right to keep and bear arms has always been a fundamental right preserved for citizens. This can be dated all the way back to post-Civil War. This court held in Dred Scott v. Sanford that slaves were not citizens, and because of this, they do not enjoy the privileges and immunities afforded to them under the Constitution. These privileges include the right to keep and bear arms. It was not until Reconstruction when African Americans were afforded the ability to keep and bear arms. During Reconstruction, the Civil Rights Act of 1866 was passed. It stated that all persons born in the United States were citizens. The act then proceeded to say that such citizens of every race and color shall have the same right, along with the full and equal benefit of all laws and proceedings for the security of person and property, as it is enjoyed by white citizens. This act essentially granted slaves citizenship and then afforded them the same rights as white citizens who were already deemed. This included the fundamental right to keep and bear arms. Furthermore, following the passing of the Civil Rights Act of 1866, the Freedmen Bureau's Act was also passed. This law granted citizens full and equal benefit of all laws and proceedings concerning personal liberty and personal security. While the respondents may want to argue that these laws were only passed to prevent racial discrimination, they are ignoring the text of these acts. The Freedmen Bureau Act and the Civil Rights Act both emphasized the constitutional right that they were granting freed slaves. These laws emphasized the constitutional right for individuals to keep and bear arms. While these laws passed did help prevent discrimination, they also granted free slaves, who were not considered citizens at the time, the fundamental right to keep and bear arms. It is clear from the passing of these two legislative acts and the commentary from those who passed it that the right to keep and bear guns outside the home is a right only given to citizens. Before the Civil War, slaves were not given the right to own guns. In fact, they were penalized for it. Following the Civil War and Reconstruction, when they were deemed citizens, they were able to keep and bear arms for self-defense. This court must look at the history of the Second Amendment as it relates to citizenship. From here, the court must realize how the Second Amendment has been a right for citizens and only for citizens, and incorporate it into the Privileges and Immunities Clause of the 14th Amendment. In conclusion, the Second Amendment does not allow for the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense. And we pray that you rule in favor of the petitioners and reverse the lower court's ruling. Thank you.
Thank you, counsel. Court will accept the case. The case is submitted. And we are done. Thank you, ladies.
That's not much of a reaction.
Wait, stop
What's
recording.
the time?